I was in the city all day today.
I know, I did too. I had to stop before the other way.
Tired.
I'm like, I'm gonna fall asleep on the table.
Yeah. Well, why don't we start our training session?
Yeah, that sounds. I don't know.
That mutes it.
No,
Yours isn't even on. That nobody wants to hear.
Thanks, Judy. All right, guys, it's been a little while. We didn't have a meeting in July, and then my friend covered my meeting last month, so I hope that went okay. Sorry about that. She's not with the firm anymore, so.
Not as good as you, but
She sucked then.
God, what a.
I think we're being recorded. Anyway, guys, I missed you, so I'm glad to be back. I thought that we would kind of take a look at reasonable conditions. We did this presentation back in 2019, so the first couple slides are just refreshers, and then I thought it would be good to look at examples from fairly recent court cases. There wasn't a lot that happened for conditions in 2021, so I think some of them go back. I think my oldest case is 2007. But fairly newer cases talking about conditions and where the court has come out. So just to get started, as a refresher, New York General City Law empowers the Board of Appeals when granting a use or area variance to impose reasonable conditions and restrictions as are directly related to and incidental to the proposed use of the property. If a zoning board decides to grant an area variance, it may impose reasonable conditions to mitigate anticipated impacts of the variance. So this language is in New York State General City Law. This language is repeated in our city code. So it's very clear that you have the authority to look at an application and determine whether or not conditions are appropriate or necessary to mitigate anticipated impacts from that variance.
is that similar to the conditions that we apply that says you must complete within so much period of time? Or
Yeah, now that's our standard time
Yeah.
requirement. The city code actually doesn't have that. A lot of municipalities have that exact language.
But that's the type of conditions you're talking about. That's an example of a condition.
Yeah, that would be an example. I think the state's intent really was about. I'm trying to think of a good one.
What about
If
something
you're,
like the river, the creek walk thing? That was a condition that I think was put on people, right?
and for site plan.
Yeah.
Yeah, so site plan, it's
Well, we don't do that.
yeah, we don't do that, but the state gives the planning board that authorization as well when they're looking at site plans to add conditions.
Right.
The timing requirement is not one that is, usually you just get that in the text of the code. You can add that because we have the power to add reasonable conditions, and that's a reasonable condition. But this one might be more focused on, well, now I'm trying to think of a new one. If someone's coming in to install a fence within, the front yard, a height variance for a fence, and you might ask them to plant trees to mitigate visual impacts, or paint it a certain color, or use a certain material. So those are really the conditions that ZBAs often consider when looking at the variances. The time one's not really something that we discuss or contemplate. It's just we add it in every time because there should be, while they run with the land, if you're not going to start the work, then the variance doesn't stay forever.
Yep.
We don't check, the building department checks to see if they've complied with those time limits?
Yes.
Because it's 6 months to get all the building permits and commence, correct?
Yes.
And then usually 2 years from that point,
Yes.
unless they get another variance.
And the reason we did those time limits is because so you have 6 months to get your building permit, but once you get the building permit, the time frames in our resolutions match with the time frames that that apply to building permits. So then they run together. So the building department has an easier time to track it.
Right.
But they'll keep track of that first 6 months.
They're the ones who monitor that.
Yes, that's not our office, that's not this board, we don't have to worry about it. That's the building department.
Yep.
They keep track. So I just wanted to clarify conditions versus alternatives. which often come up. So conditions, those are going to be our requirements that we place on the enjoyment of the relief that the board is ultimately going to grant. Conditions are meant to mitigate the impact of the approved project on both the neighborhood and the integrity of the zoning law. While an alternative is something that the board, we usually work with the applicant, we make suggestions, we want to see how they can reduce the variance. So the alternatives is just a different version of relief that comes from them reducing their variance request. So that wouldn't be a condition because that's going to be part of the ultimate approval. So conditions must relate solely to the particular land that is the subject of the application and must not concern unrelated land or other issues. They must relate to the land and may not be personal to the owner. They must relate to the legitimate objectives of zoning and not to matters related closely or related solely to the operation of the business. So you can't grant a variance just for Mr. Smith. That variance applies to that property and runs with the land. An example of something you can't do is place a condition on a variance upon a property owner's agreement to dedicate land that is not the subject of the variance application. You can't do that. You have to focus on what's the subject of the application. You can't condition a variance on an applicant making plantings on public property or plantings on his neighbor's property. They don't have a right to go on property that's not theirs and make the plantings. So the mitigation has to focus on their property and has to pertain to the application.
When you say land that's subject to the application, does that mean the land in the variance area or the subject property, meaning that parcel?
It could be that parcel. You'd want to make sure, let's say they're installing a fence.
Yeah.
And you're thinking, planting a couple trees behind the fence could mitigate the visual impact. It would seem more natural. Well, requiring that person to plant trees on the back corner of the parcel, not near their fence, I think we'd have a hard time relating
Sure.
that back to the variance, just because you want to see them, that area doesn't look
Yeah.
good. If it's about, hey, you're taking a bunch of trees down, we want to see you plant trees in other areas, then again, you're making that connection. How does this relate back to the variance? Another example of something you can't do, you can't impose a condition that seeks to regulate the details of the operation of an enterprise. So rather than the use of the land on which the enterprise is so you can regulate the use of the land on which the enterprise is located, but you can't regulate operations of the actual business. So these types of conditions are invalid because they do not seek to ameliorate the effects of the land use at issue and are thus unrelated to the legitimate purposes of zoning. So, someone comes in for a fence variance and you're going to say, okay, we're going to grant you the fence variance, but we want to see your hours of operation go from 9 to 5. We can't do that.
But what about in the situation, remember when we had the flower shop and they were buying the bar? And people were talking about the bar and
Yeah.
they were talking about hours of operation and stuff like that. That's not an area variance.
Exactly, so that's a use variance. Now you're right, you're automatically kind of
Talking
talking
about
about
the
the
use.
use.
Gotcha.
And so you're trying to impact the impacts to the community that might happen if that flower shop was operating till 11 o'clock at night in a residential neighborhood. Then that connection makes sense.
Right, okay.
So what can you do? What are some good examples? Conditions can properly relate to fencing, landscaping, screening's one I keep mentioning, outdoor lighting, noise, building enclosures, emissions of odors, dust, smoke, refuse, vibration, things pertaining to the health and safety of the surrounding community. You want them to, again, relate directly to the use of the land in question, and they should be corrective measures designed to protect neighboring properties against adverse effects of that use. So if we're talking about conditions, it's important to identify first, what are the adverse effects of that use? And then come up with some conditions that could address that. Conditions imposed to protect the surrounding area from a particular land use are consistent with the purposes of zoning. Again, seeking to harmonize the various land uses within the community. We want things to work together. We want people to be healthy and safe. So that's what the purpose of conditions is. So let's talk about some conditions. I have a case from Village of Rockville Center. In this case, the petitioner is the leasee of property located at 340 Sunrise Highway in the Village of Rockville Center. In 2013, the petitioner sought to demolish the existing structure on the subject property and build a 5,400 square foot restaurant. Given the square footage of the proposed structure, the village's zoning code required that the petitioner have 54 off-street parking spaces. The subject property did not have any off-street parking spaces. In applying for a building permit, the petitioner, as a means to remedy the lack of off-street parking spaces, proposed to merge the subject lots with the adjoining property located at 330 Sunrise Highway, which was also owned by the leaser of the subject property. The petitioner anticipated that the proposed merger would allow it to utilize an exception in the zoning code's off-street parking requirement for interior restaurants that abut municipal parking fields. The adjoining property was also adjacent to a municipal lot. Okay. The village's building department then issued a building permit to the petitioner. When the petitioner's restaurant was substantially completed, the building department discovered that the proposed merger between the subject property and the adjoining property never took place.
Wow.
It didn't happen. So as a result, before issuing a certificate of occupancy, the building department directed the petitioner to apply for a parking variance. So he did. He relied on a license agreement which allowed the petitioner to access the adjoining property's 40 exclusive parking spaces between 4 p.m. and 12:30 p.m. on Mondays through Fridays. So, the Zoning Board of Appeals granted the parking variance, but imposed several conditions, including that the restaurant's operating hours be restricted to 4 p.m. through 12:30 a.m. on Mondays through Fridays, and that valet parking be mandatory. On the same day, the ZBA granted the petition. Oh yeah, that part doesn't matter. Okay. So, important facts. I gave a lot of information. The ZBA granted a parking variance, but they restricted the hours. And they restricted the hours because, remember, the applicant was relying on a license agreement that he had. So he had 40 parking spaces between 4 p.m. and 12:30 Mondays through Fridays. So they said, okay, we're going to grant you your variance, but your operating has to be restricted from 4 p.m. to 12:30 a.m. Mondays through Fridays, and you have to have valet. So what do we think happened? Do you think the court upheld this condition?
No.
I think the tricky part for me is the valet aspect of it. But on the hours part, I would think they would uphold that part.
So you think they uphold the hours, but not the valet?
Yeah, being me, I say they upheld the valet.
And not the hours?
Disallowed the hours.
Okay, across the board. So the court, when they're doing these types of cases, they always start out with the rule, right? And the rule is the zoning board, where appropriate, can impose reasonable conditions and restrictions as are directly related to and incidental to the proposed use of the property aimed at minimizing the adverse impact to an area that might result from the grant of a variance. So the conditions imposed by the ZBA, including requiring the valet parking and restricting hours of operation of the restaurant to coincide with the hours of access to 40 off-street parking spaces granted in the license agreement, were reasonable. Since conditions related directly to the use of the subject property were intended to protect the neighboring commercial properties from potential adverse effects of the leasee's operation, such as anticipated increase in traffic congestion and parking problems. The court said that the need to alleviate traffic congestion, which was documented, by requiring adequate parking facilities is a legitimate consideration for the ZBA, and thus both conditions were appropriate. Now, I will say, I know that the planning board in Beacon has contemplated, if not conditioned certain site plans to valet requirements. Beacon does have a parking problem in some areas, so you want to always consider, is there enough parking on the site? And a valet plan is sometimes part of that kind of compromise to figure out, what they can do. So yeah, so in this case, controlling the hours of operation to coincide with when they had that lease access to those parking spaces was appropriate. Otherwise, if you're outside the scope of those hours, people would have nowhere to park.
Interesting.
Yeah, any questions on that one?
How do they enforce that?
Well, that's hours of operation, so when they issue the certificate of occupancy, there'll be a restriction, this restaurant business is permitted to be open from 4:30 to,
More the fact that everybody's valet parking. How do they enforce that everybody who goes there is using the valet parking?
well, all that matters is that the restaurant had a valet parking option and had it available. So if a patron is not going to use the valet, that's no fault of the restaurant. That's the patron's choice. I know I never have cash, so I try not to valet.
What's the value of the valet? And how can,
So that would allow the restaurant to allow patrons to enter without them circling around, without them trying to find a parking spot. They pull up, and the valet can search and park in wherever they're going to do it in an organized fashion. It tends to be more organized. There's less circulating. They're in control of the traffic circulation when they're valeting.
okay, thank you.
I think the hours, I think both of those things are hard to enforce, just hours as well. I mean, Dave Buckley has made comments about, that. But however, of course, obviously different places may have different enforcement mechanisms. I think in Beacon, there's, 2 or 3 guys.
Yeah.
And if it's a nighttime operation, they're not going to be enforcing hours. If we, restrict hours to a business at 8 p.m.,
Right.
they're not doing it. I don't think, the police are enforcing these zoning restrictions, so that would be maybe not wise for us to do, but that doesn't necessarily mean it's a bad thing. Oh, here's the police right now. I lied. But, another municipality, it might make sense depending on how they enforce.
Yeah,
And let's say they had access to parking, but it was far away from the site. That's another reason you'd have valet, so that your patrons don't have to go to that parking location and then come up. All right, next case. Less
but if
facts
they
in this
had
case.
joined the properties like initially thought, that would not have been an issue at all. No variance would have been required of any of that, right?
Exactly, because then he would have had enough parking.
Yeah.
It's just that he chose not to do it.
Got it.
And he got caught, and then he had to get a variance, and they conditioned it. Before, he would have had no problem, there were no limits on the operation of his business, but he didn't do what he had submitted he was going to do. So that's the problem. Do what you say you're gonna do,
Yeah.
is the lesson. Okay, so this one is Hempstead. Less facts. The prior owner of the property had obtained a use variance, allowing the property to be used as a 2-family dwelling. The variance had to be renewed every 5 years and imposed the condition that one of the 2 units be owner-occupied at all times. However, the use variance lapsed in 1996 after the prior owner failed to renew it. In January 2018, the petitioner applied to the Zoning Board of Appeals of the Town of Hempstead to reinstate the use variance. This is 19 years later. After a hearing, the board granted the variance subject to the same owner occupancy condition that had previously been imposed. What do we think? Legal?
I think we.
So it's for a use variance.
Right.
The use is a two-family dwelling. Two-family dwellings were not permitted. It's a single-family district. And it said that it had, one of the units had to be owner occupied.
I am inclined to think that whether or not this upheld would actually turn quite a bit on what the reasons were articulated, or what reasons were articulated for imposing the requirement.
Now, interesting, the court doesn't go into the reasoning. Now, I think you could probably backtrack and pull the resolution to see what their reasoning was.
So they just reinstated the previous variance granted. They did not go through the 4-factor test.
Well, they
for use-
did. So they re-granted the use variance. So they failed to renew it. He had to apply for a use variance again.
So it's another variance application, not the reactivation of a previous variance.
Right. He can't just come in and say, "Hey guys, can you restamp this?"
Oh.
He's got to come back in. They got to go through the 4 factors, and then they conditioned it. To
So is the
owner
question
occupied.
then, is someone barred from applying for the same variance if they let the time lapse? Is that the legal question?
No, the legal question is the condition of the owner occupancy requirement a permitted condition?
I didn't
Oh.
know that that was a
I would
permitted
think so.
I didn't think that was a committed condition that the zoning board of appeals could enforce. It is. I always thought that was part of the zoning law, that it had to be owner occupied.
We are the ability,
Well,
we
and that's
are the
actually-
Well,
we're the
so
relief
now
valve
you're-
of the zoning code.
This is that a condition can't be taking the place of legislation of general application. So if the reasoning is just, well, if we're gonna have 2-family homes in this neighborhood, they should all be owner occupied, that's effectively legislating as a board. If it's something that's more particularized to the
There's something that
application.
years ago, Montos will tell you, it was a big deal.
Well-
We did this a lot because we were
Yeah.
trying to get rid of a surplus of non-owner occupied.
Right.
Multi-family dwellings, and that was I don't know who came up with that. I don't think we did. I thought the zoning law was changed that it had to, and then we just upheld it, and we could grant a variance maybe against, but I didn't think that we could impose that variance,
So
impose that condition.
your questions are in the right area, but you're getting confused. You're focusing on Beacon, and this is about a different municipality. Now, in Beacon, you're absolutely right. Actually, accessory apartments have to be owner occupied, and I think that's what you're thinking. That is a requirement in the city of Beacon, the owner occupancy. It's been
Your
legislated.
question is, academically, can we impose owner occupancy in that?
Exactly. That is academically
Yeah.
Yeah,
a good
and
question.
and I think the answer to that is we can.
And the answer is yes.
Yeah, I think the
You
answer to that is
can.
we can.
Because the idea being, and it's the same reason it's been legislated in the city of Beacon that accessory apartments be owner occupied, the idea is that you still have someone who is a part of the community and not just, a renter who might be there for a short period of time. And people believe,
Non-owner occupied was giving the city a real problem with not taking care of it, and taking care of the properties, all kinds of things were going on that other people in the neighborhood didn't like,
That's right.
and that's the thought. Now, if it wasn't legislated in Beacon, and for each situation you believe the owner occupancy was required, you actually could do that condition. It might be beneficial if you find yourself continuously getting these applications and continuously granting them with that condition that you petition the council to legislate. But you can, in fact, adopt that condition for everyone. Similarly,
Okay,
sometimes
so you have
it's,
it.
sometimes it's actually for special use permits in Beacon for accessory apartments. They always add a condition, they call it their standard condition, that accessory apartment won't be used as a short-term rental. Now, they actually just passed new legislation, I believe, on Monday, that now legislates that accessory apartments can't be used as short-term rentals. But previously, it was just a condition that was always added to those applications.
What did they pass?
The city council passed legislation on accessory, amending the,
ADUs?
yes.
Airbnbs,
Hmm.
right?
No.
No, they can't.
Accessory apartments.
Getting an accessory apartment and putting an accessory apartment over your two-car garage to be used as an Airbnb is
They
that's a
passed,
short-term rental.
Right, you can't, the city has separate short-term rental provisions in its code. So you can get a permit that would allow you to use your home as a short-term rental. But accessory apartments are their own thing, the idea being that these are going to be units available for more than 30 days.
Yeah, I thought they had put in the law that they could not be used for short-term rentals.
That's in the accessory apartment local law.
Right.
Yes, the accessory apartments that you're getting site plan approval for cannot be used as short-term rentals, but there is a separate short-term rental law for
Right.
other situations. Yeah,
But I've heard
cool. Now,
differences.
I'm gonna pause here. I guess we can start the meeting, but don't you guys worry. I've got some more cases coming up for next month.
Let me just
Yeah.
ask a question, because it's definitely something that's occurred to me when the issue of conditions has come up. With some conditions that would be imposed, like in particular, say, operating hour restrictions that are attached to a use variance, that's basically the existing apparatus of the city ought to be able to keep track of those. When a certificate of occupancy is issued, it's going to be claused to reflect that restriction. What if a restriction or a condition is being imposed and I'm trying to think of what a good example would be. But generally stated, suppose someone wants a variance to do a property subdivision, and for whatever reason or reasons, we're okay with granting that variance, but we want a restriction on what's being done with the property going forward, so that okay, well, actually, I think about a hypothetical here. Suppose you've got a single lot with 2 occupied residential structures on it, which under the zoning code would, if you're proposing to build that now, would not be permitted.
Got it, yeah.
And the owner said, okay, so what I want to do is I want to subdivide this lot, and I don't have enough size, or I don't have enough width, whatever. There's some dimensional restriction that's preventing that subdivision. But they say, okay, look, you've already got 2 occupied structures on this property. Drawing a line between them isn't actually going to result in any additional burden. And we go, well, okay, we want to make sure that 2 doesn't become 4, and that somebody then turns around and says, I want to build an accessory dwelling unit here, whereas from what we're starting out with right now, if you had 2 occupied structures on one lot and you applied for an ADU, the answer would be no. If we put a restriction on that said, you can't put an accessory apartment on this lot, I mean, certainly the people that came in and applied for the variance would know about it, but you wind the clock forward 20 years and someone buys the property, this isn't going to be something that's recorded in the title history. It's not going to come up on a title report. You see where I'm going with
Yeah,
this?
and I think I have an answer. So in every resolution, we have the tax parcel number at the top, and they get filed with the city clerk. And the city clerk has a property file for every property. It's your responsibility when you go to purchase that you're looking at these types of you're looking at that file to see what resolutions exist, what limitations might exist, and someone good doing a title search should locate that. And if not, and you go and you build an accessory apartment when one wasn't permitted, and it's discovered that you did something that was expressly prohibited, you're going to have to go back to the Zoning Board of Appeals to try and get that resolution either amended and to get that approval. And if it doesn't work and you did something that's not allowed, then you'll have to remove that accessory apartment. Now, in your situation, we would probably go about it differently, and I actually had that exact case in another municipality, and it came down to legalizing the second home that was on the same residential lot. And that would involve getting a use variance, because having 2 principal structures on the lot wasn't a permitted use. Automatically, that limits you. You can't do any more. You are maximum capacity. You have already gotten a use variance for this additional home. You can't do any more. And so when you go into the building department with a building permit application to build an accessory apartment or another structure, the building department is going to catch that as well. Because even if you didn't look at the file, they're going to look at the file, and they're going to know, what the limits are of that property and that it doesn't comply with zoning. Does that make sense?
It makes sense, but I'm concerned that it might not actually work out that cleanly in application, especially if the period of time's gone by. I could definitely see the building department approving plans without anybody digging back on 30 years, what's on file from 30 years ago, and then you've got a property owner who's like, okay, I guess I could have looked in the city's files, but I didn't, and now I built the structure, the city gave me a permit, you didn't tear it down.
They'll know right off the bat that there's something wrong with that property because it doesn't comply with zoning. So they're going to determine whether it's a legal non-conforming, they'll have to find that resolution to figure out, well, why is the setback, why was this small setback permitted? Or was it not permitted and they just did what they want? So at that point, they're reviewing the site plan and the applications that they're getting in, and they're going to notice that it doesn't comply with zoning. And they're going to see, at what point was it permitted. And if it was never permitted, then a variance is needed to legalize that situation.
So I know we need to get into the meeting, but just, I guess the question I would close with is, okay, so when the city sells a tax property, like a tax lien property, usually these things are falling down. They normally have redevelopment conditions attached to them. The way this is done is they file a deed with the county that says this deed is reverting to the city if all these conditions aren't met, and that way anybody who's thinking about buying this property, if they exercise any level of diligence whatsoever, is going to know about it. Even if they don't exercise diligence, if they're trying to get a loan on it, the bank's going to exercise diligence.
Right.
What do we have the ability to say, if you want this condition, we want a new deed recorded so that the world is on notice that this restriction applies going forward, and it's not a situation where 30 years from now, no one finds out until they put this application into the city, and the city says, oh, we were digging through our files and we found this thing. It's a question that I've had before. It hasn't directly come up in one of these meetings yet.
I think, I'm not sure, you keep saying the restriction.
Yeah.
In that situation, what restriction are you talking
Yeah, I was kind of thinking, I need a hypothetical.
Well, the hypothetical I gave was you're subdividing two lots. You're subdividing one lot into two, and the two lots that you're going to end up with are both going to have single-family occupancy residences on them. And the concern is, well, right now, in this area occupied by the one or potentially two lots, we've got two structures.
Yep.
If we don't do anything, there won't be any more than two structures. It'll be a pre-existing nonconformity. But if we split this into two, either owner is going to be in a position where they can say,
Have
oh,
to
I
build
want
an accessory
to
building?
build an accessory apartment, and
Yeah.
now we've got 4 occupancies on that same lot. Or what was that lot started out with?
What is the variance that was granted in your hypothetical, though?
Allowing the lot to be subdivided, even though for whatever area variance reasons it shouldn't be subdivided. Maybe it's not wide enough.
So,
Contested, approved the stuff.
But they would have had it. Go ahead, Drew.
so I was going to say there's several approvals that are happening. First of all, you're going to have subdivision approval from the planning board, and that'll be recorded on a plat filed with the county. Then you're going to have to get variance approval from the zoning board of appeals. That subdivision plat is going to show clearly when someone comes in with a survey and they say, I'm going to build this accessory structure, and they go to the building department with their building application, they're going to see, well, this doesn't comply. The accessory structure would only be permitted. There are other limits at play, right? You are going to have to deal with your setback requirements. So if your house isn't, if the lot is non-conforming and now you're building an accessory apartment, well, I'm assuming, very likely that accessory apartment's probably not going to be able to meet setbacks. And the building department's going to see, because it's going to be on a survey, they're going to have to show what the setbacks are. So automatically, someone's going to see that this lot doesn't comply, and now what's going on. Now, if it does comply, there might not be anything restricting them from having, you know, an accessory apartment. But they're going to see that it doesn't comply, they're going to look for that variance and notice the restrictions at that point. I mean, that's what the building department does, that's their job.
I think we're running over.
Yeah, I think we better move on with our meeting, but pertinent
Get into
topic.
that next time. That was a
Yeah,
good
right, you know, and if you have any questions, you guys all have the cases also referenced in your note packets. So, you know, if you have anything you want me to, you know, hey, can you make sure you like answer this? Shoot me an email, I can make sure I come back with all answers.